5, 4, 3, 2, 1, start.
This appeal has impugned the judgment and decree dated 2 January 2005, which had reversed the findings of the trial judge dated 19 September 2004. Full stop. While judgment and decree dated 19 September 2004, the suit filed by the plaintiff Krishan Singh seeking recovery of possession in respect of two plots, that is, plots number 32 and 33, measuring 250 square yards, situated at village Kanota, Jeend, as also recovery of rupees 1,70,000 had been dismissed. Full stop. While the impugned judgment, the suit of the plaintiffs stood decreed. Full stop. The case of the plaintiffs, as is evident from the averments made in the plaint, is that the father of the plaintiff number 1 had on 5 February 1988 purchased plot number 32 of the aforenoted suit property. Full stop. Plaintiff number 2 had purchased plot number 33 on the same day. Full stop. These plots were purchased through the defendants. Defendant number 1 was a witness to the aforenoted documents of purchase. Full stop. Stanza. In November 2000, the defendant had threatened to encroach upon the property of the plaintiffs. Full stop. In February 2001, they had encroached upon the land and committed criminal trespass. Full stop. Suit number 73/2001 was filed by the defendants seeking an injunction against the plaintiffs. The plaintiffs had made a statement that the defendants would not be dispossessed without due process of law. Suit of the defendants stood withdrawn. Full stop. A second suit was thereafter filed by the defendants seeking permanent injunction and declaration. The plea set up by the defendants was that they had become owners by adverse possession. Full stop. The defendants have illegally trespassed into the property of the plaintiffs. They are also liable to pay damages at the rate of rupees 11,000 per month. Full stop. Present suit was accordingly filed. Full stop. In the written statement, the defense set up was that the suit is not maintainable. Full stop. The contention of the defendants was that the said two plots had been purchased for a consideration of rupees 1,40,000. Full stop. Senja. The plaintiffs did not have the money to pay the said consideration. Defendant number 1 had advanced a sum of rupees 70,000 to the plaintiffs. Full stop. On account of family relations, no receipt was exchanged between the parties. Parties had agreed that the physical possession of the sued property would be handed over to the defendants on a rental basis. Full stop. The defendants are tenants in their own right. They cannot be evicted. Full stop. 1 PW was examined on behalf of the plaintiffs. Full stop. The site plan of the sued property had been proved as exhibit PW1/A. Full stop. In defense, the defendants had adduced their evidence. Full stop. On the basis of oral and documentary evidence produced in the courts below, the trial judge was of the view that the plaintiffs have failed to discharge the onus to prove that they had become owners of the sued property in terms of the documentary evidence relied upon by them, that is, a power of attorney, will, agreement to sell, etc. Do not transfer title. Suit of the plaintiffs stood dismissed. Full stop. Stanza. In appeal, the impugned judgment had reversed this finding. Full stop. The impugned judgment had noted that the plaintiffs have become owners of this property while the aforenoted documents relied upon by them dated 5 February 1988 PW1 had averred that the physical possession of the suit land had also been handed over to them contemporaneously with the execution of the said documents. Full stop. The defendants had failed to show their status in the sued property. Testimony of DW1 was held to be unreliable and no credence was given to his version. Full stop. Suit of the plaintiff stood decreed. Full stop. On behalf of the appellant, it has been urged that the judgment of the trial court is illegal and arbitrary full stop. The impugned judgment in para 14 had noted that the plaintiffs have failed to bring on record any evidence to establish the fact that the defendants had encroached upon the suit land in January-February 2001 full stop stanza. Attention has also been drawn to para 16 of the impugned judgment, wherein it had been noted that no evidence had been brought on record by the plaintiffs to prove his claim of damages at the rate of rupees 11,000 per month full stop. It is submitted that thereafter the court having awarded damages at the rate of rupees 5,000 per month is a gross illegality full stop. For this proposition, reliance has been placed upon a judgment of this court full stop. It is further pointed out that PW2 had given his affidavit by way of a rebuttal evidence. This evidence was rightly rejected by the trial judge. The impugned judgment could not have relied upon it as PW2 had not come into the witness box in chief. Evidence in rebuttal of such a witness could not have been read full stop stanza. For all the aforenoted reasons, the judgment being perverse, it is liable to be set aside full stop. It is further submitted that the first appellate court, while reversing the findings of the trial judge, was required to record reasons in arriving at the reversed finding, which it has not done full stop. For this proposition, reliance has also been placed upon JT 119 SCOP Gujjar and others full stop. Arguments have been countered full stop. It is pointed out that the judgment suffers from no perversity full stop. Findings of fact can be interfered only if there is substantial question of law. In this case, no substantial question of law has arisen full stop stanza. Record has been perused full stop. The case of the plaintiff is that the father of plaintiff number 1 had purchased the suit property by agreement to sell power of attorney, receipt and will dated 5 February 1988 full stop. This was qua plot number 32 full stop. Plaintiff number 2 had purchased the plot number 33 full stop. The defendants have not denied this factum full stop. It has in fact been admitted that the plaintiffs had purchased the aforenoted plots. Defense of the defendants is that they had lent a sum of rupees 70,000 to the plaintiffs for purchase of the said plots. Parties had agreed that in terms of the aforenoted money advanced by defendant number 1 to the plaintiffs, defendant number 1 would retain the physical possession of the premises as a tenant full stop. Defendant has also admitted that no rent thereafter was demanded by the plaintiffs. No document to this effect was also executed between the parties full stop. This version of the defendants is palpably false and rightly held so in the impugned judgment full stop. DW1 in his cross-examination has admitted that he has no documentary proof to show that he had paid rupees 70,000 to Krishan Singh. No such entry had also been maintained in his book of record full stop stanza. He has admitted that documents of purchase of the plaintiffs dated 5 February 1988 had been witnessed by defendant number 1, namely Shri Ram full stop. DW1 had on oath deposed that on the date of execution of the aforenoted documents, that is for plot number 32 in favor of father of plaintiff number 1 and plot number 33 in favor of plaintiff number 2, the physical possession of the suit property had also been handed over to the plaintiffs full stop. It is also not in dispute that the aforenoted documents had been attested by defendant number 1 as a witness full stop. It is also admitted that 2 suits had been filed by the defendants full stop. The first suit was suit number 73/2001, which was a suit for injunction, had been withdrawn on the statement of the plaintiffs that they would not dispossess the defendants without due process of law full stop. The second suit filed by the defendants had sought relief of permanent injunction and declaration full stop.